The hidden legal power of the term, without recourse. One tiny phrase can shift the entire burden of liability, and most people don't even know it exists. It's called without recourse. Let me show you why those two words can protect your assets and change the way you use contracts forever. Among the most potent and least understood phrases in the lexicon of negotiable instruments is the term without recourse. Though often dismissed as boilerplate language, this phrase operates as a powerful liability shield under both UCC Article 3 and broader commercial contract doctrine. The phrase without recourse is explicitly recognized in UCC Section 3-414C. If an endorser states that the endorsement is made without recourse or otherwise disclaims liability, the endorser is not liable under subsection A to pay the instrument. In practice, this means that when an individual signs a negotiable instrument, such as a promissory note, check, bill of exchange, or other security, with the words without recourse, that signature severs personal liability. The signer is effectively saying, I endorse this instrument for processing or transfer, but I assume no responsibility for future payment, collection, dishonor, or enforcement. This language can completely shift the risk of non-payment onto the party accepting or processing the instrument, often a bank, lender, or third-party assignee. In the commercial world, without recourse clauses are commonly used during the sale or assignment of receivables, but their utility extends far beyond that. When used correctly in consumer financial transactions, the phrase has transformative potential. For example, if you endorse a car financing agreement, mortgage note, or credit application without recourse, you may eliminate your liability for that instrument's repayment, provided the other party accepts the instrument knowingly. The moment of delivery is critical. According to UCC Section 3-420A, acceptance of a signed instrument constitutes legal acceptance and, by extension, contractual finality. Critically, most Americans unknowingly issue blank endorsements when signing financial instruments. This is the functional equivalent of handing someone a signed blank check. By contrast, writing without recourse converts a blank check into a non-liability voucher, an act of protective legal engineering. Furthermore, if a financial institution or party refuses to process a properly executed negotiable instrument bearing the phrase without recourse, and then still enforces repayment, it may constitute fraud, conversion, or unlawful enrichment, grounds for civil litigation and punitive damages. Footnote: this section reveals how the phrase, without recourse, functions as a legal firewall against financial liability in negotiable instruments and commercial transactions.